Good afternoon. This is the final case of the first day of the July 2020 session of the.
I forgot my mask.
Oh, I run a tight ship here. This is the, as I was saying, the last case of the first day of the Court of Criminal Appeals in Nashville for July 2020. I believe you weren't here with us in June, I don't think, Mr. You don't have to stand up.
No, Your Honor, I was not here.
Okay. And I don't remember if, Ms. Decker, were you here with us in June? Okay, under the conditions, since, okay, you're a little bit familiar with it. Of course, everybody's familiar with the Supreme Court's order about everybody's supposed to wear a mask in court houses. We will excuse you if you are more comfortable while you're arguing removing your mask. We can do that because there is social distancing. I believe this lady's at least 6 feet or 8 feet away from you. So you'll be safe to remove your mask if you feel the need to while you're arguing. And to my right is Judge Bobby Holloway from Columbia. To my left is Judge Tim Easter from Franklin. I am Tommy Woodall from Dixon. Each side is allowed 20 minutes, as you well know, and if you represent the appellant, you of course can reserve some of that 20 minutes for rebuttal time if you'll let us know when you start arguing. And you can come up to the podium to argue if you choose. It's perfectly fine, and we actually encourage you to argue from the desk, and you don't have to stand up. It's more important that we be able to hear you, so you may need to adjust that microphone a little bit that's in front of you there, pull it towards you or something to be heard. But you're welcome to come up here to argue if you want, but you're certainly encouraged and welcome to argue from the table and sit down if you choose.
I'm a little stuck in my habits. If it's all right with you, I'll go to the
Come on up, Mr. Stiant.
Your Honor, would the court mind if I took my mask off?
No, I think there's enough distance here.
Okay. Good to see you all this afternoon. Peter Stryantz of the Nashville Bar here on behalf of defendant Joseph Hendry, and I would like to reserve 3 minutes for rebuttal. I'm not sure that I'll need the full 20 minutes that have been allotted. As you all know, this is an appeal from the final judgment or order of the criminal court for Wilson County denying my Rule 35 motion, where Mr. Hendry was asking the court to take another look at the sentence that had been imposed. I realize it was an 11C1C plea agreement that was struck between the parties, although the forms in Wilson County do not contain the language Rule 11C1C, nor did the proffer agreement contain the language 11C1C, but I think it would be disingenuous for me to argue to the court that this was not a binding 11C1C agreement, and I realize that I have to abide by the McDonald standard that was reaffirmed in State v. Patterson by the Tennessee Supreme Court. I know you all are familiar with the record. There are a couple of things I wanted to go through just to sort of set the scene in this case. This was a case that had received some attention in Wilson County in Middle Tennessee back in January of 2015, when this very tragic, unfortunate event unfolded late on the night of January the 5th of 2015. Mr. Hendry was indicted by the Wilson County grand jury pretty quickly. He was indicted on January the 16th of 2015, charged with felony murder, premeditated first-degree murder, attempted first-degree murder, and 4 counts of aggravated assault. As you all know from reading the briefs, the charges arose out of an incident on January the 5th, 2015. It was a shooting incident into a home on a street called Floral Street in Lebanon, Tennessee. In January of 2015, Joseph Hendry was 18 years old. Unfortunately, he was somebody that was under the influence of Schedule II drugs, Schedule IV drugs, and had really lost his way back at that time. He was in the company of two Wilson County residents. Mr. Hendry lived in Davidson County. He was in the company of two Wilson County residents, a man by the name of Marvin Andre Bryant and Timothy Wade. And I think that the proof that would have been shown had any of these defendants gone to trial was that on the night of January the 5th, 2015, Mr. Bryant suggested that this group of three shoot up the house, in the vernacular of one of his rivals, a man by the name of Rashad C., who lived on Floral Street in Wilson County. Unbeknownst to Mr. Hendry, he did not realize that that house was owned by Mr. C's grandmother, and there were a number of people living in the house. Not that that excuses any of the conduct in any way. And the reason for going over there was that Mr. Bryant was much aggrieved by a shooting that had occurred at his home that he attributed to Rashad C. And this shooting event was in retaliation for that. All three of these young men traveled together in Mr. Hendry's vehicle, arrive over on Floral Street, and all three of them shoot randomly into the house. The police investigation that followed indicated that the SK gun, the assault rifle, the clip was empty. They found 12 casings there. It was later determined through the cooperation of Mr. Hendry that Timothy Wade was the one who was in possession of the SK rifle. I think it's significant to the Rule 35 analysis, and what I still think is an important factor, which is unfair and unwarranted sentencing disparity, that Mr. Wade had a prior robbery conviction that had been pled down from aggravated robbery and especially aggravated kidnapping. The proof, coupled with Mr. Hendry's proffer, also demonstrated that Andre Bryant fired 5 shots from a .45 caliber pistol. Also important to this court's analysis, I hope, on the issue of the proffer and unfair sentencing disparity. He had a prior aggravated robbery conviction that had been pled down from criminal homicide, aggravated assault, and especially aggravated robbery. And Mr. Hendry fired 3 shots from a 9mm pistol. That 9mm pistol, had the case gone to trial, that was Mr. Wade's pistol. And I think it's significant that Mr. Hendry, when he cooperated with the state of Tennessee and engaged in this series of wide-ranging proffers, fully accepted responsibility that he was the one that had fired the 9mm pistol. That's a pistol that was associated with Mr. Wade. If Mr. Hendry had been devious in any way, he could have easily put that firearm on Mr. Wade, but he didn't. He acknowledged that by the luck of the draw, that was the weapon that he had fired into the home that evening. You know from the record that in the fall of 2016, we engaged in that proffer agreement. And I think for Rule 35 purposes, it's really significant for the panel to know that until Mr. Hendry met with law enforcement, signed that proffer agreement, and engaged in that series of meetings, law enforcement had no idea of the involvement of Marvin Andre Bryant or Mr. Wade, and they certainly didn't know who fired the weapons. And again, Mr. Hendry admitted that he had fired that 9mm. You've seen the transcript of the Rule 35 hearing where I called Officer Detective David Wilmore of the Lebanon Police Department in an attempt to show the value of Mr. Hendry's cooperation, and also to show that there were some significant post-Hendry sentencing developments that I thought that the court, even under the stricter McDonald standard, could take into consideration and address what I thought was unwarranted sentencing disparity. I think it's significant that when we entered into that proffer agreement, and I acknowledge the proffer agreement contains the terms and conditions of the 25-year second degree 100% sentence, but at that point in time, the state had no idea whether they were going to prosecute Bryant and the other individual. At that point in time, the judgment was written, and it was sort of aspirational that if ever called upon, he would have to provide truthful testimony, Mr. Hendry would. So there were really some significant events after the proffer that were the direct result of his cooperation. Officer Wilmore was able to go to the Wilson County grand jury armed with the information in Mr. Hendry's proffer and caused the grand jury to return indictments against Bryant and Wade, charging the identical conduct, the identical offenses that Hendry had been indicted for. He acknowledged that this was clearly jointly undertaken criminal activity. He acknowledged that any of those three defendants, I used the word serendipitous during the hearing, but that's really, it's no excuse, but any one of those individuals firing into the home could have been the one that delivered the bullet that ended in the tragic result of killing that young girl, Miss Patton. So in terms of the Rule 35 analysis and the McDonald test, I still believe that Judge Kane could have considered the return of the indictment, the successful prosecution of these other two individuals that, had Mr. Hendry not come forward, would have been totally unknown to law enforcement. So they were able to vindicate, Wilson County was able to vindicate the conduct fully of all three of the individuals that were involved in the case.
Did the state have a strong case against your client from the very beginning?
I think they had a very good circumstantial case against Mr. Hendry.
For premeditated murder?
Not for premeditated murder.
Felony murder?
I'm sorry, Judge.
For felony murder?
Perhaps felony murder. They would have been able to put him at the scene, clearly. There was his vehicle. There was gunshot residue outside of the car. He was profoundly under the influence that night, so he was seen by other people who could say that they saw him engaged in activity with firearms and things like that. So circumstantially, I think they could have placed him at least in an incriminating posture. Whether they could have put him right at the scene, I don't know, but they did have a stronger case against Mr. Hendry than they did the other two, because they had no idea if there were any other individuals that were involved.
And he was looking at a felony first-degree murder conviction, along
Absolutely.
with attempted first-degree murder of several other victims. And you were able to get a deal for second-degree murder?
That was the agreement that we reached as a result of the proffer. But again, at that point in time, in October of 2016, when that proffer agreement was reached, there were a lot of unknowns. We did not know, and I'm not sure the state knew, what their next step was going to be in terms of, do we have enough to get an indictment? Can we get these individuals convicted, whether by trial or by guilty plea? And with the passage of time, triggered by the proffer that was given by Mr. Hendry, all of those things fell into place. My position basically was that the state was satisfied with 25 years before they had any of those other things secured.
Well, your client was satisfied with 25 years also without knowing whether they would even indict the other two people, right?
And at that moment in time, he was satisfied. As between his alternatives, not the best alternatives in the world, he was satisfied. But I think under the McDonald test, if there are, and I'm looking at Patterson that talks about the McDonald test. And it talks about that the purpose of the McDonald test and the Supreme Court's analysis of it is that it harmonizes rules 11 and 35 and enables a trial court to protect against unfairness to the defendant in the exceptional case.
But
If
would you agree with me that the Supreme Court's version of Patterson anyway doesn't really help you?
it gives me a higher standard. I've got that binding 11 C1C agreement.
Which was what we would call a package agreement. You agreed to
Yes.
25 years. And in Patterson, that was a judge-fashioned sentence,
Yes,
correct?
yes, Your Honor, absolutely.
And from my read of Patterson, at least the Supreme Court's version of it, that was a major factor, that it was the judge who fashioned the sentence, and he's allowed, or he or she is allowed, a little bit more leeway in modifying that than you would be when it's a 11C
Right.
packaged agreement. Correct? Is that the
you-
way you read
You are
Patterson?
correct, but there does survive a glimmer for a defendant who has entered into an 11C1C agreement as well. If that defendant who reached a binding agreement with the state can show that there were significant post-sentencing developments, and to borrow from the Patterson opinion, in the exceptional case, and the only way that I can get any relief is if this panel decides that what happened in Mr. Hendry's case was truly exceptional. And I think it's pretty exceptional that his cooperation resulted in all those positive things for the state of Tennessee. It's extremely rare that someone's cooperation leads to the indictment of two other individuals with competent proof and results in the conviction of those two other individuals. So if the court was to say, well, we find the return of the indictment, the successful prosecution, to be an exceptional circumstance, then I think the door is at least opened for Judge Kane to maybe reassess that 25-year sentence. And I wasn't asking him to go out of the range, of course. It's 15 to 25. It's all going to turn on whether you all think that the circumstances of Mr. Hendry's case are exceptional enough. I know we have a binding agreement. I know that I've got the laboring war here, but what my focus has been is all of the positive things to the state of Tennessee after that agreement was signed, the proffer agreement was signed in October of 2016, and the results that they were able to receive. Thank you.
Okay.
May it please the court. Catherine Decker for the state of Tennessee. And are you able to hear me through the mask?
Yes.
The trial court did not abuse its discretion in denying the defendant's Rule 35 motion to reduce his sentence. The court applied the correct legal standard and required evidence that there was an unforeseen post-sentencing development that would permit modification of the defendant's sentence in the interest of justice. On the question of whether there was an unforeseen post-sentencing development, the court properly found that the co-defendant's sentences, the lesser sentences, were not unforeseen. And that actually was defense counsel's argument to the court and to this court on its brief, was really about the co-defendant's lesser sentences. What this case boils down to is the very simple fact that the defendant pleaded to a higher sentence than his co-defendants because the state believed that it had a very strong case against the defendant, and the state believed that it had a very weak case against the co-defendants.
Other than the cooperation in the statements by Mr. Henry, did the state have anything to corroborate the two other defendants' testimony other than I did it and they did it too? Do you understand my question? Was there corroboration of
No, there
Mr.
wasn't, and that's the key to this, is that even though defense counsel has talked about the evidence and and stated that this was what the proof would show against all the defendants had the defendants gone to trial. That's not exactly accurate, because the evidence that he is discussing is what was proffered by the defendant. But the police officer who came to testify at the Rule 35 hearing stated that they were never able, the police were never able to corroborate any of the information that the defendant gave to them in his proffer. And that is why when the state assessed the value of its cases against the defendant and against the co-defendants, it valued its case against a defendant much higher and offered a 25-year plea. But it valued its case against the co-defendants much lesser because it had no corroborating evidence. In fact, just specifically to mention some of the points that defense counsel has raised, the police officers were never able to verify, never able to find any of the weapons. So although the defendant said that one of the co-defendants shot this SK rifle, there was no corroboration as to that. Defendant informed the police that a girlfriend of somebody would be able to corroborate whatever he told the police. The police contacted the girlfriend and the girlfriend said, no, I cannot corroborate this. There was no corroborating evidence. And so as the trial court reasonably found, every case is different. There is no case exactly alike. Every defendant is, in the trial court's words, its own little entity. They have their own lawyer. They enter into plea negotiations in different ways. And each case has its own strengths and weaknesses. The court properly found that a lesser sentence based on the relative strengths of the case or the weakness of the case in this case is not unforeseen. So the court reasonably found, properly found, that in this case, the defendant could have foreseen that the state would offer lesser pleas to the co-defendants based on their unique and, in this, as it turns out, weaker cases. But furthermore, the state has legitimate reasons for the disparity of the sentences, and that is their assessment that the co-defendant's case, if taken to trial, would be quite weak. And they assessed whether they could get over the hurdle of even getting a conviction on the co-defendant's cases. And so this post-sentencing information that the police officers learned actually speaks against modifying the defendant's sentence in the interest of justice, because there's nothing unjust in pleas for lesser sentences for weaker cases. And for these reasons, the defendant did not meet the requirements that he needed to meet to prevail on his Rule 35 motion. I will just briefly address the notion that the benefits that the court should have looked at were the mere fact that the co-defendants were indicted. But first of all, or most significantly, this is not a post-sentencing development, because in the defendant's proffer, or in his request, to make this proffer, it was already, the trial court already knew when he sentenced the defendant was making these proffers and to implicate the co-defendants. This was something already considered by the trial court. This is not a post-sentencing development. The post-sentencing development that the defense argued at the Rule 35 motion and argued in his brief was simply the lesser sentences of the co-defendants. So the trial court did not abuse its discretion in finding that those lesser sentences were not unforeseen post-sentencing developments, and the state praise of this court affirmed the trial court's ruling.
So just to make certain, to put some specifics to what you're saying was not unforeseen. The defendant in this case, at the time he entered a plea of guilty to testify against the other co-defendants in this case, in exchange for 25 years at 100%, should have foreseen that the state might do a plea agreement with one of the co-defendants he agreed to testify against, where that defendant would get 12 years at 30%. That's what you're saying, it's not unforeseen?
Well, sure, I am saying that because it's completely foreseeable that each case is assessed on the basis of its own strengths and weaknesses.
So was it a strength for the state in Mr. Bryant's case that Mr. Hendry was going to testify for them?
Well, but you have to pull back a little bit farther than that, because their first concern is whether they should even take the case to trial. And when they viewed their case as quite weak because none of the information that Mr. Hendry had provided to them they were able to corroborate. So they really weren't, as the prosecutor told the trial court in its closing argument in the Rule 35 motion, that's not really what their first concern was, whether they should offer particularly low pleas, because they did not think they had the proof at trial that they needed.
And so did they anticipate not having the truth they would need to get a conviction against Mr. Bryant, Mr. Wade, when they made a deal with Mr. Hendry to get him to testify truthfully against those two people? So they knew that his testimony really wasn't needed?
No, at that point, they wouldn't really know what they were going to be able to do with the information that Mr. Hendry would provide them.
So it was not foreseeable to the police, but it was foreseeable to Mr. Hendry?
I don't think I quite understand your question.
Well, you said that Mr. Hendry should have been able to anticipate what would happen, that the co-defendants would be able to plead to much lesser sentences. And that was not something that was unforeseeable, or at the right terminology, unforeseen or unforeseeable. But the police couldn't foresee it at that time.
What was not unforeseen was that each case can develop into a strong case or a weak case. It was that is not unforeseen. And so every party knows going into it that whatever information the defendant could have provided could have turned out to be a strong case or a weak case. And what the trial court said was it was not unforeseen that it turned out to be a weak case, for both co-defendants.
And I assume then, without any testimony from Mr. Hendry, there would have been no case.
Well, as it turns out, but it could, if the police had been able to corroborate this information, then possibly.
They took something to the grand jury. I assume they took primarily Mr. Hendry's statements about the co-defendant.
I don't know what they took to the grand jury.
Well, they didn't corroborate anything else. So I guess they took the fact that someone was killed, but they had no other corroborative proof.
But to get an indictment from the grand jury is just such a much lower burden. And so all of this is fluid, and as they're getting information from the defendant and then trying to corroborate, and then at some point realize that this is just not going to be strong cases against the co-defendants. And the question before this court was the trial court, did the trial court abuse its discretion in deciding that the defendant could have foreseen, because it's just reasonable for any person to have foreseen that the cases against the co-defendants could have developed into weak cases. And the trial court did not abuse its discretion in making that conclusion.
Anything else?
No, Your Honor, so I just pray that this court affirm the trial court's ruling.
All right. you have 5 minutes of rebuttal
I
left
think
if you
it was
need.
3 minutes, Judge, and I'm not even going to use that much.
Okay.
When
You had, reason I said 5, you had 2 minutes you didn't use, and I usually,
Okay.
you don't have to take it, but you,
And I won't take it. Just a couple of things. I asked Detective Wilmore, although I called him on direct at that Rule 35 hearing, I got to ask him some leading questions and nobody really objected. But I asked him I said, you wouldn't present a totally uncorroborated case based on accomplice testimony to the Wilson County grand jury, would you? And he said no. And that was right on the heels of him sort of minimizing the proffer and that they had trouble corroborating the proffer. I know that Judge Easter knows this from his background as a prosecutor and my background as a prosecutor. You're certainly not going to indict a case in the hope that you can hoodoo somebody into pleading guilty. You've got to have a good faith basis to present it to the grand jury, so there had to be some corroboration. If the case is as weak as the Attorney General is suggesting, the state got a huge benefit of the bargain. They were able to rely on this, I guess they're going to say uncorroborated proffer statement of Mr. Hendry, and they were able to buffalo these two unwary defendants into pleading guilty based on that. I think that there were significant post-sentencing developments, post-proffer developments. And as Judge Holloway said, I don't see how it was foreseeable to Joseph Hendry that the state was going to offer the types of offers that they did in the case. One, particularly with the records that those two individuals had, that one gets 15 at 35 and the other gets 12 at 30. And Joseph Hendry, who but for his testimony and cooperation, those individuals would be driving the streets of Wilson County right now, robbing and pillaging and doing what they do. So I think that it was not foreseeable that the state would make those type of offers to those individuals. I think that his cooperation was a boon to the state of Tennessee, that they got a very great benefit. No one knew what was going to happen when he signed off on that proffer in October of 2016. So there were, under the McDonald test, which we have to shoulder and we have the burden, significant positive impact to the state of Tennessee that should be taken into consideration by the trial judge. To just say, well, y'all cut an agreement, you got your 25 years, you need to go on, I think ignores the benefit to the state and ignores all those developments. If this is not an exceptional case and these are not developments, then for somebody who has an 11C1C agreement, the legislature just needs to write into Rule 35, we don't want to hear from you again. So there is a basis for the court to give Mr. Hendry some relief.
that concludes our docket for today. We'll be back here at 9 o'clock tomorrow morning. So we'll be in recess till then.